Yes.
My lord, may I be permitted to mention, my lord, this is a matter, my lord, the stay application which, my lord, the Chief Justice has given me liberty to move. My lord, it was mentioned day before yesterday. It is running in the list as on yesterday's list, my lord, item number 8. My lord, it is a stay application, my lord. If it is not heard today, my lord, the electricity connection will be installed, my lord. If lordship recalls, I had mentioned it day before yesterday. Honorable Chief Justice was pleased to list it upon dispensation of Rule 26, my lord. But however, we've notified the parties, my lord, it have been served. If your lordship may be pleased to take it up today.
2 p.m.
Grateful, my lord.
Your Lordship, I'm seeking leave to prefer an appeal without the certified copy. There are 3 appeals in. This is the
When the order was passed.
21st November, Your Lordship. I have applied for the certified copy. The file is actually there is a contempt that has been filed and it is running in the list because the file is in the court. We've not been able. I've written to the Registrar General as well, and the file has gone in the department, but still we've not got the certified copy, Your Lordship.
All right.
Sincerely.
To file, you have given the server copy.
Your Lordship. My lords, may I?
Photocopy of the application?
Your Lordship, appeals order is there.
No. Photocopy of the application.
Your Lordship, I have annexed that. I have annexed.
My lord, may I have my lord Honorable Justice Bhattacharya's leave to mention a matter for extension of the interim order, my lord. This is the matter for the reservation of the transgender.
Come on,
My
Monday.
lord, the interim order is till the end of November, and it's.
Come on, Monday. No difficulty.
Lordship, may I be
permitted to mention one matter. Underwriting order 41 rule 11. Lordship, this is the matter on the last
This is
occasion.
not a bench.
Lordship, there is an urgency. Lordship,
This is
on
not
the
a
last-
bench, sir.
Lordship, may I be permitted to mention a matter for inclusion in the list? I have instructions to withdraw the appeal. It's the
What is this?
the first appeal.
First appeal, we don't have a determination. We are sitting in a Chief Justice's determination.
Lordship.
This bench is not a regular bench for order 41 or appeal. Yes.
Lordship.
Come on Monday, mention it. We will take up, don't worry, at 2 p.m. or what?
My lord, may I mention one thing? My lord, it's appearing in the list today as item number.
But this is not a bench. Kindly consider that.
My lord, pertaining to the determination of the Honorable Chief Justice and my lord, may I be, I pray for my lord filing an appeal, my lord, without certified copies, my lord.
When the order was passed.
25th November, my lord.
What is the urgency?
My lord, the urgency is that it is a tender matter. The work order will be issued any day, my lord. That is what.
You have given this server copy.
Server copy is there.
The application for certified copy.
That is not there, my lord, with me.
File,
but my lord,
give with
Annex.
the application. Annex.
No, annex with the memo.
With the
may
memo,
I, my lord,
annex
hand
with
it over with the application, my lord, copy of the application in a while, my lord.
copy of the application for obtaining the certified copy.
Yes, my lord. In a while, my lord. I don't have it with me right now.
First apply, then.
It is applied, my lord. I don't have a copy.
Without
Please
the
give a photocopy and next with the memorandum along with the server copy of the
giving,
order.
my lord.
Do you understand what my brother is saying?
Grateful, madam.
My lord, this is my mention slip. My lord, in this case, the learned trial court should have held the respondent and defendant deliberately, willfully, and intentionally breach all the terms or contact, and defendant also refused to the learned court judgment and decree.
What is with regard to which determination?
Yes, sir.
No. What is
the matter?
Matter the FAT 378-200.
This is not a bench, regular bench. This is only for Chief Justice's determination. That is another bench.
Achha.
So come on Monday.
Greetings, sir. Sir, yesterday morning, actually, my father, 5 individuals came, sir, and they said that they were DRI officers, and so they came to my home in morning around 6:30, and so they took my father without any arrest memo, summon or nothing was there, and they took my father. They said that there's some questioning required because my father is an importer, sir. So there's some questioning required, and they took my father and they asked me to come around, like you can come 1 hour after. So I went there, sir, and whole day like.
Have you filed any application?
No, sir. I just have a letter, sir. I just have a letter. And
File an application.
File an application as in, sir?
For reliefs, what you want? You
Uh,
have to file an appropriate application.
Sir, I have no advocate, so I don't know how to file that.
You can take an assistance of a legal aid also,
Okay.
provided if you come within the zone.
But sir, my father is still in their custody without any memo
Without
or
an
anything.
application, it cannot be taken up.
It cannot be taken up. Okay. Thank you, sir.
Yes, call. Take it up.
I'm appearing for the respondent.
Kindly, my lord, allow me 5 minutes time. Counsel of this case, Advocate Mr. Ranjan Kali is on way. Advocate Mr. Ranjan Kali is on way. Please give me 5 minutes time first.
Well, the matter is already there. They have spoken.
Yes. Yes.
My lord,
Mr. Kali.
without going into the my lord, that so far, my lord, the Bapna Motors judgment, my lord, my respectful submission is if your lordship takes into account rule 9(2), what has been, my lord, as your lordship yesterday, my lord, so yes, my lord, without going into that question, my lord, whether there is a question of redemption or not, my lord, if you
Is a primary question.
no,
What
that
are
is
you
the primary
talking
question,
about?
but if we otherwise, my lord, if it ultimately
No otherwise. If the law is very static and very clear, we can't go beyond that.
no, but
What are you talking about that we forget every law?
no, I am not saying that. But rule 9(2), they have not complied. But it's admitted fact. Because,
That again essentially a question of fact. We cannot go into that.
but if it is apparent on the face of it,
Then
But-
the writ is not
My lords,
maintainable.
may I just make a
Well,
small
and the
submission on this
The
point?
moment you argue that the writ is not maintainable, you go before the DRT.
but then, my lord,
May I-
well, it's
may
the
I-
equitable jurisdiction, my lord.
No, equity in accordance with law.
But-
Equity not dehoves
Your
the law.
lordship kindly, my lord, appreciate my position, my predicament, my lord, I would say, my lord.
The
Here
predicament
is the
we
case
have.
where I have paid the entire amount, my lord.
Sir, that is what is again you are saying every time. When a right to redeem was there, you did not.
Right, my lord.
When a right to redeem extinguished, now you have come up with
My lord, the
that
right,
every money I have given.
my lord, the right to redeem,
My lords,
my lord,
it had-
that point.
Sorry, under section 9, I think the section
Amended.
13,
Yes,
section
13A.
13 amended
39, my
act.
lord, after 2016, my lord, that right
So-
evaporates
so-
once the moment.
So
But
your
what
right
my
to
lord-
redeem
Yeah.
extinguished.
Here, my lord, I am, my lord, since, my lord, it's a question of law also, my lord. If they have not
The object,
complied,
Mr. Kali,
Then
the
we'll
object
go.
of
Then we'll
object
go with that.
object of amendment has to be taken into
Yes, but-
My lord,
The Papna is
Yes.
is
Yeah,
very
my
clear.
lord, on factually, my lord, if your lordship, my lord, distinguish Bapna from this case.
my lords, how can Bafna be
Because, my
distinguished
lord,
from this
here,
case?
my lord, the sale has been confirmed. Here,
There's
my lord,
there's no
only
reasoning for
25%
it to
has
be
been deposited.
distinguished. There's no reason. My lord, may I just make a small submission?
My lord,
That is more
It
an
had-
the
emotional-
bank has already, I am
more
very
an
surprised,
emotional
my lord, the
argument.
bank is,
It
my
had
lord, after
fallen
taking
from my
the
lords.
money.
Mr. Kali, how the sale is confirmed under
Well,
the procedures of
My
the
lord,
Surface Act?
before the sale is confirmed, my lord, the moment, my lord, the consideration balance is paid, sale will be confirmed, my lord.
No.
Sale
Was
is
from the
already
provisions-
confirmed on the
So as
30th
per
of October.
But without paying the entire money.
Yes, provision is.
Yes,
Rule
Rule 9, Rule 9.
Rule 9.
Have
Yes,
you considered
yes.
Rule 9?
confirmation is on the day of the auction.
Oh, madam,
Lord,
he is saying
Not
so
that
big. Let us see on the test,
Yes,
the
my lords.
anvil of law. Let us understand
Very well.
Yes,
more.
ma'am.
Very well.
More he will speak, more he will damage his case.
Very well, my lords.
my lord, here only one point, that is the that is, my lord, creating, my lord, all the obstacles.
Yes.
That is the only question, my lord.
So how
But
can
my
you overcome that obstacle?
My lord, so far, my lord,
Give
the
us something so
yes,
that
my
we
lord,
can overcome that
Bapna, my lord,
obstacle.
this is very clear, my lord, on redemption point. My lord, there is absolutely, my lord, no quarrel with that proposition. My lord,
We
also,
are
my lord, as
bound
per
by
the
that.
statute.
Mr. Kali,
But-
we are bound by
But
that.
my lord, kindly,
কোনো লাভ আছে? He has not worked on the brief. He has not applied his mind. He has not gone into the nuances. Unnecessarily সময়টা নষ্ট করার কোনো মানে হচ্ছে না।
my rule 9(2), my lord, in my what has fallen from your lordship, my lord, that rule 9(2), well, if your lordship applies that, well, since they have not complied 15, the borrower consent has not been obtained. Well, since, my lord, the price is, my lord, at par
This
with.
is what you gathered it from the observation of the bench, and then you slept in the night so peacefully.
Mr.
and
Bose,
then
my
did
lord,
not work on that.
I had a talk with Mr. Bose, my lord. He has given me this judgment. You will also kindly consider, my lord, this judgment once. On this point, rule 9.2.
There are two conflicting views of two high courts.
My lord,
Two conflicting views of two different high courts.
my lords, even this proviso 9 that had fallen from my lords, we had also gone back and done a lot of research on it. There are judgments that say that the consent is required only if it is below the reserve price.
That is the first proviso, madam.
That
The
is the
first
Delhi High Court
proviso-
judgment.
My
The
lords,
Delhi High Court judgment you are
yes,
citing.
my lords,
Yes.
Delhi High Court.
He has not worked, but both of us has worked.
The Delhi High Court, which
There
is
is a
also
Madras High
following
Court
a
judgment
Madras
also.
High Court.
How to do it. That was a case where the auction, the bid was below the reserve price.
Right, my lords.
So the first proviso says that no sale shall be confirmed or completed if the offer is below the reserve price.
Very well, my lords, yes.
But the last proviso, which I just indicated, it says, suppose if it is at par,
Yes, my
then
lords.
is it necessary for taking a consent of a secured creditor, you are a secured creditor,
Yes, my
and the
lords.
borrower to confirm the sale?
So, my lords, on that
The
proposition,
object was something different,
yes, my lords.
because the object of the public auction is to get
The best price.
of the best price
Very well, my lords, yes.
which is available, which the willing buyer is intending to offer and a willing purchaser, both bona fide
Yes, my
willing
lords.
buyer and a bona fide willing purchaser to get it.
Yes, my
If it
lords.
appears that something more has come, will it create any fetter? Only thing is whether it was within your competence to confirm the sale at the reserve price without resorting to this. Their right of redemption goes, there is no doubt about it.
Yes,
You
my
can't
lords.
say it. The right of redemption goes, they can't come.
Yes, my lords.
Now it appears subsequently before the sale is complete in all respect. I'm not talking about confirmation, talking about a completion. It appears that there has been a higher price which is given to you.
So, my lords,
So in that event, if that is taken into consideration, then one has to understand that whether you have followed the mandates of the statutory provision or not. It appears that you did not follow. You did not follow. If for such reason, if it falls out, then what? Then the confirmation of sale at the time of while accepting the bid was not correct.
my lords, may I just
That
make a
could have come to them and asked, you are giving a consent. Authorized officer is conducting a sale.
yes, my
you.
lords. My lords, may I just show this judgment, my lords, because we had also really
Look at the
deliberated
Madras
upon
High
this.
Court judgment. It says something different.
My lords, I have the
Delhi was
Madras
a
High Court
case
also.
Of below the reserve price. Delhi was a case below the reserve price.
Yes, my lords.
We are talking about a case where the reserve price
Is the
equivalent.
same. My lords, that is the Madras High Court judgment. I'm
That
carrying
is
the
what-
judgment with me
yes.
also.
Madras High Court, I think 2010 judgment.
2011, yes, my lords.
2010 judgment.
And that has been followed by the Delhi High Court, my lords, where
In 2022. but it was
2022, my lords.
below.
Yes, my lords.
We have worked more.
I'm sure, my lords.
In
that
Delhi
is
High
the
Court
case.
judgment, the expression such price has been interpreted to mean it can be a price below the reserve price also.
For which the consent of the borrower is required
Not
because he's
necessary. Below is no consent required because the proviso say no sale can be done. That is, if
sale
you look
can't
at
be
the-
confirmed,
look
my
at the
lords.
language. Now there is two distinction, confirmation and completion.
Yes, my lords.
We are
That
talking
is
about
that is the
completion.
question.
Don't take a confirmation. Confirmation is done the moment you accept the bid.
Yes, my lords. The proviso says that I can't confirm it below the reserve price.
That is what is there.
And when
So
can
that
I cons
means when you open the bid and find that it is below the reserve price, you cannot accept it. That
Yes,
is
my
what
lords.
is the purpose.
My lords, but
Confirmation,
my
the
case
moment
is
you accept the brief, confirmation is there, but completion is not there. Completion will come the moment the rest of the amount is paid.
right, my lords. But my case is it's not below the reserve price. It is at
It is-
par with the reserve
So
price.
why the further proviso was added at the last? First proviso was already there. Legislature consciously knowing that this proviso is there,
Yes, my lords.
yes, added another proviso. Then the tool of interpretation what? If the latter provision comes, that means the legislatures were conscious that there is an earlier provision, yet they incorporated it. The reason being that you have to take consent because can't, that's the reserve price. That's called a base price.
My lords, may I just show the judgment once again? Because in my understanding of the judgment, the proviso further provided is supplemental to the first proviso, which means that that will not apply independently.
No.
That
no,
will apply if
no,
if
no,
the
that is
sale is
what.
below.
There are two aspects. When the two provisos are there and
Yes,
both the
Manoj.
provisos contemplates a different eventuality of the situation.
Yes,
So
Manoj.
one does not override the other, because the canon of interpretation is that the court cannot interpret a provision which would render that provision unworkable or redundant or osseous. No, the court will harmonize. And while harmonizing, the court will uphold the applicability, or I would say, one must complement the other.
Yes,
Both can be
Manoj.
given effect.
What is the purpose? When the first proviso says there is an absolute bar or embargo created on the authorized officer to confirm the sale. No sale can be effected if it is below the reserve price. That is the first proviso.
Yes, Manoj. That I
The
understand very well.
starting word is no sale.
Yes, Manoj.
That means an absolute bar.
Yes,
And
Manoj. I can't confirm it.
Then it says that, please, last one says, if it is at par, because it is not higher than the reserve. The word is higher than the reserve price. That means if it is at par with the reserve price, then it says that you can do it.
He may with
There
the
are two
consent
ways
of the
of
borrower.
understanding it. Two ways. One is that either if it is at par, then it applies only to that situation. Then the consent is to be obtained. Second interpretation may come. If we interpret so rigidly the word higher than the reserve price, that's the language used in the section.
Yes, Manoj.
If it is not higher than the reserve price, that means either it must be a reserve price or below the reserve price.
Yes, Manoj. That is my understanding of the
I'm-
proviso.
That
Manoj.
is the
Sir.
Delhi High Court judgment.
Sir,
That is the
because
Delhi High Court
I'm
judgment.
taking-
Manoj.
Interpreted the
the
expression
two
of such
situation
price.
will come. Then I'm taking an academic class for you.
Yes, Manoj.
The two situation will come. Either it is at par with the reserve price or below the reserve price. If you harmonize both the provisions, if the one proviso says absolute embargo that you cannot confirm the sale below the reserve price, then the second provision says that not in case of a below, but if it is at par, then you'll have to take a consent. So this is how both the provisions have to be harmonized. They are complementing each other. They are not really supplanting each other.
There is also
You are
an
talking about supplanting. They are complementing and supplementing each other, not.
there is also
Look,
another
but-
embargo in Rule 8, Sub-Rule 6C or something, that
860,
it
yes,
cannot
Manoj.
be
The
sold
judgments
below
have
the
been.
reserve price. There's another embargo.
Yes,
Rule
Manoj.
8.
But that is not the case in my. That is not my
Yes.
case because it is
So
not falling
these
below.
provisions are to be read harmoniously.
Yes, Manoj. And Manoj, I also understand, Manoj, it had fallen from Manoj that the best price should be available.
Absolutely.
Tomorrow, if he was a separate or another successful auction
Madam,
purchaser and
the
he came up.
difficulty is the moment we say that you have not followed those
Yes, Manoj.
procedures, what is the fallout of this?
Yes,
The
Manoj.
sale has to be scrapped.
Yes, Manoj. If that
the
is the case,
sale
then yes,
goes-
Manoj.
If the sale goes, then there is no publication.
Then of course, Manoj
Then
still has the right to
right.
redeem. But
Revise.
Manoj, as
Revise,
the
you can
advocate
take-
for the bank,
If the
Manoj,
redemption right revives, then
yes,
you
Manoj.
cannot affect the sale if they pay you the entire amount.
That is, Manoj, if the entire sale is vitiated on a procedural lapse. But Manoj, as the advocate of the bank, Manoj, we say that we have done no procedural lapse. I will rely on the judgment of the Delhi High Court, Manoj,
That
where
is
it is.
below the reserve price. We are saying that this judgment is not pointed to an issue which is involved here. Had it been below the reserve price, we would have blanketly rely upon it. Though we are not bound, it's a persuasive effect.
Yes,
But
Manoj.
still, we will consider the first proviso. We'll interpret it. No difficulty, madam.
Manoj, may I then just place the judgment once before Manoj?
Even if
Thereafter, I
you're
leave it up to Manoj. Thereafter, I leave it up to Manoj because it.
As a responsible counsel,
Yes,
when
Manoj.
you find a judgment is distinguishable on facts as well as on a point of law,
Yes, Manoj.
is it right on your part that since you have worked on it, found out I wanted to throw it to the bench to consider it? When both on facts as on law, there is a distinguishing feature.
Manoj, but in this judgment, para 21 says, may I just read it out? It's just a 4-line para. The only remaining ground is whether the sale is vitiated because the alleged violation of the second proviso to Rule 9 when the property has not been caused to be sold for a price higher than the reserve price, but for the reserve price itself. My lords, that is the case. It is similar to my case, my lords, because even in this case, it is being sold at par.
That was a case of below. That is I would say it's mere obiter. There was no occasion.
My lords, it's written here that
Obiter, because that
but for the
fact does
reserve
not
price
apply.
itself. My lords, this judgment says that is the sale vitiated because it's not being sold for a price higher, but for the reserve price itself. My lords, the facts are the same. Even in this case, in the Madras High Court, my lords, it is being
That is
sold.
what is the Madras I am saying. Madras is pat on the point.
And Madras has been
Madras is
upheld in
pat
the
on
Delhi
the
High
point,
Court
but
judgment.
the Delhi is not.
But my lords, the Delhi High Court has referred to this judgment and has said that we are in view of this.
Madam,
My
the
lords.
law is very clear. The judgment of the other high court may have a persuasive value on the another high court, but it does not bind the another high court.
Very well, my lords, I understand that. my
Now,
lords.
if we find that the interpretation which is sought on the basis of a judgment appears to be wrong,
Yes, my
can
lords.
we not correct it?
Absolutely, my lords. That is, as per my lords,
So why you have to assist the court in a proper manner?
my lords, because if we read this judgment, I had actually thoroughly gone through it. It had explained that why the consent of the borrower is required under the second proviso.
True.
If we understand it on that point of view,
True.
the borrower is already aware of what my bid amount is. He knows that my bid amount is 1 crore 10 lakhs because we are serving the sale notice to him. The reason why the consent comes into play, my lords, is to let him know that his dues are X amount, but I'm selling his property for a lesser sum. That's the reason I need his consent. Not because he's not aware that the bid is coming for a lesser sum of money.
Amount you can't. There is no provision that you'll have to seek a consent. You can't interpret because the purpose of first proviso and the last proviso, we can't make a synchronization between it. Why? Then why it was necessary? They could have included it within that first proviso. The language which is there is mandatory in nature in the first proviso.
Yes,
It
because
starts no sale. It
shall be
starts with the word
confirmed.
no sale. If it says with a negative word, then makes it more mandatory. Then you
Yes,
have no latitude, no leniency, nothing you can do on that.
Question of consent becomes irrelevant there.
Not necessary at all.
My lords, but if we see it this way, it says that the sale cannot be confirmed.
What is
It
the-
does not
then
say that I
when the
cannot
sale is
sell it at
confirmed,
all.
I'm
It's yes, my
then
lords.
tell us when the sale is confirmed.
My lords, in my understanding of this proviso,
No,
I
not
cannot.
with the other section. When the
With-
sale is confirmed, these are the rules.
Yes,
The
my lords.
statute also talks about parent statute when the sale is confirmed.
Just yes, my lord. I'll just get to that once.
হাতে আছে সেই জন্য বললাম। Mr. ASG, they are very junior members of the bar. We are investing some time on that. Otherwise,
I have one prayer. In Telangana matter, your question has been
Yes.
yes.
we'll take it up immediately thereafter.
I'm told by Mr. Arti Bajitra,
He's there.
for once, I need to continue for.
No, I don't think so. Don't underestimate the pace of the bench or
I
understanding.
have a prayer, in the event it continues, kindly do not take it up at 2 o'clock, it's a contempt day for 2 o'clock, so many contempt. Kindly fix it at 3 o'clock, we are armed with the report of the Home Minister.
Whatever. Let us see.
My lords, under 9.2, it says that the sale will be confirmed in favor of a purchaser who gives me the highest bid. In my case, there was only one person who had come forward
Madam,
and he has given me the
what
reserve.
I'm saying, you must bear in mind the distinction between a confirmation of a sale and a completion of a sale.
No, the sale will definitely be complete once I receive the entire sums of money.
So this distinction one has to bear in mind.
Yes, my lords.
So one has to understand that if the sale is not complete, may be confirmed, then what court or what the right of the parties are. So let us decide. We know it, what to decide.
Because even after acceptance of the bid, what you are terming as confirmation. Thereafter, there are situations which are contemplated under various sub-rules of Rule 9 where the sale will fail. So it's the ultimate thing is the completion of the sale.
Now,
not
my
the
lords, may I just
confirmation.
make another small submission? Anyway, today is the last date I'm supposed to get the remaining sum of money from the auction purchaser. Till date, I've just received 27.5 lakhs. I have not received the remaining sums. His extended time period also ends today as per my lords Rule 9 subclause 5. So, my lords, let us wait for a day. Let us see whether we receive the entire sums of money. If we don't, regardless, the entire sale will be rendered
deal with-
infructuous, my lords.
We will deal with that situation also.
Don't worry.
We will deal with that situation also.
My lords may just kindly takes in all I'll say, my lords, kindly takes into consideration the Madras High Court because there the facts are the same, my lords.
Can
Where the reserve.
formally cite
That
those
is what I
situations.
want. I say the Madras High Court is apt
Yes, my lords.
on
So, my
the
lords,
facts as well as the law, not Delhi.
because here, my lords, reserve price, at the reserve price, it has been
I
sold
know, madam,
and it
what
is
you
being
saying,
said that
what
the
you
consent
saying.
is not required.
How long you are there? How long?
My lords, it's been 11 months for me, my lords.
11 months only.
Yes, my
And
lords.
I think I have more than years
I'm sure, my lords.
over there. Nearly 19 years on that side.
My lords, it's my
Another
duty to
thing-
just show, my lords, the judgment. My lords, may I just tell the relevant paragraphs? If in that case is required.
Over there at that point of time also. So before you come and then say you made a research, we have already had a research and told you that these are the judgments which are there.
Yes, my lords.
Just say the yes.
I have the Delhi High Court if my lords would like the Delhi High
Madras
Court.
you have not cited. You have
Not
given only
cited.
Kerala.
Sorry, my lords.
Madras you have cited.
I have, my lords, I have not, we have not filed any affidavit as such. We are
No,
just.
The judgment.
There is no question and law points need not be pleaded.
No, my lord. So we are just placing the judgment. We are citing.
These are the citations. You are relying on a proposition of law.
Yes, my lords.
There's no difficulty for that.
We are
affidavit
relying
is
on
required.
this. We are just no, my lords. I
Don't
was.
inculcate this. 11 months practice is still learning.
Yes, my lords.
You can cite a judgment, no difficulty, not required. Under the CPC, law is not required to be pleaded.
My lords, we are citing the Madras High Court judgment.
Amount কত জমা দিয়েছে?
Amount 27 lakh টাকা জমা দিয়েছে। And it is 135.
135.
What is the amount you have?
1 crore 35 lakhs. The reserve price is 1 crore 10 lakhs.
RP is 110. Thanks. They will pay the litigation costs, expenses.
The
That will
further
be
expenses 75,000.
75,000 legal expenses.
We'll pay, man.
You raised a bill.
Yes, my lord.
But they are getting 25 lakhs more, my lord. They are getting 25 lakhs more. 1 crore 10 plus 25.
So benevolent act on your. So benevolent action.
In spite of the liberty granted by the learned single judge, you did not.
But that
At
was
that
only
point
10
of
hours time, my lord. Kindly see the time.
15 lakh, then comes to 20 lakh. Yes. And
Much obliged,
the
my lords.
order be passed today on a day.
Much obliged, my lords.
Only one indulgence, my lord, I would be seeking. My lord,
Yes, call.
only provide that they will hand over the possession immediately, my lord. It is in
Huh?
my favor.
Lords, we would
Possession is
definitely
with
hand
us,
over the possession if that's the case, my lords. It depends on the order of the court, my lords.
In course of
আজকের
the
দিনেই এটা disposal হবে।
আজকের দিনেই disposal.
Much obliged, my lords.
But I have concluded my argument regarding that not maintainability. Now he has to argue that maintainability. But just one averment of his petition just I will show, and I will not. Kindly come to page 36. Page 36, paragraph 25. Just Millard, from the bottom of fifth line, right hand side. The petitioners have approached this honorable court seeking for quashing of the FIR on the ground that the said case reek of malicious and malafide approach. So he is practically asking for quashing of the proceeding, and Millard, prayer is also that investigation is proceeding.
Yes. You are taking a preliminary objection.
And that the maintainability, I argued, Millard, that the appeal is not maintainable in a matter, in a writ petition. Shall I start again?
Yes, yes. Can you just?
Yes, Millard. This, what has happened, Millard? He kindly come to Millard the prayer of the writ petition.
That is what I was just looking at, page 55.
55. Asking for quashing of the investigation, etc. in the proceeding. But more particularly, he has said in the paragraph 25 of the, that is at page 36. Page 36. The petitioners have approached this honorable court seeking for quashing of the FIR on the ground that the said case reek of malicious and malafide approach, which is palpable from the narration of the Swans. Now, Millard, against the learned Singhaliya passed an order. Order to one.
We have annexed it with the supplementary affidavit.
Yes.
Give it a copy of the
The
supplementary.
order is also there. The order dated
Order dated 11.
11/11.
The correct, Millard. Learned advocate appearing for the petitioners challenging the continuance of the Bhatpara police station case number.
Another notice be issued. Another notice be issued on for 18/11.
Yes, right. Against that order, he has filed this. Now, I took the point, Millard, whether the maintainability of the appeal itself. Last week, I have argued that.
What we were thinking.
Millard, that kindly, just to remind to your lordships, Millard, just take the judgments, Millard. I have handed over the judgments.
You are Ramkishan Fauji.
Ramkishan Fauji.
And
two Calcutta High Court judges.
High Court in Suparna Kanjilal Chakraborty and
Subarna Kanjilal Chakraborty there. Your lordships, Subarna Kanjilal Chakraborty was there. State of West Bengal there, etc. And other side was Mr. Mojumdar. He had taken the point that is not maintainable. His leader was there. On behalf of Shubhendu Adhikari, they had taken the point that not maintainable. It was not maintainable. Hold it. Now, this has been, two judgments have been held that the order passed in a writ petition which is criminal in character.
Criminal flavor.
Criminal flavor. Then the
latest patent, there is no
further appeal. Especially in the case of a quashing and etc. There are two arenas have been divided by the Honorable Chief Justice in another matter. Police inaction, transfer of investigation. That's a different issue. But when you are asking for quashing of the proceeding, then
you have a letter patent with us.
Yes.
My lord, your lordships kindly, your lordships will find from the Ramkishan Fauji itself.
This is.
No. What is that clause?
My lord, clause 15.
My lord, also see clause 40 and 41.
Just 1 minute.
Now you say that the judgment is wrong of the Shubhendu Adhikari's matter. No, you say, I don't have any difficulties. But state of West Bengal, when will come in appeal, will say not maintainable. And when you will not get the order, you will say I am not maintainable. But I have no difficulties. But once for all, it has to be decided. Because of Shubhendu Adhikari, it is not maintainable, it will be held. But because of the state, it will be maintainable. That cannot be the criteria. That time he will come. You are the persons who have said this. All you are the persons who have curtailed this. No, on fundamentally, I feel that there should be an appeal. And every time it is not possible for to go to Supreme Court, that I feel it. But you have called, you have curtailed this. Appearing against the state, that time you are all vociferous. 15 councils will come from Delhi here, not maintainable, etc., etc. Manoj, kindly come to paragraph 17 of the Ram Fauji's case. Fast.
No, I just, Mr. Bandyopadhyay, as my character goes, I want to look at the provision of law first. Then I will go to the judgment.
No, here the judgment has been quoted. That's the reason. Exactly, that has been quoted.
Clause 15.
Clause 15.
Yes, give us 130 seconds.
Please.
From the civil courts of emergency.
Latest print এনেছিস latest print বার করতে এটা তো তুই কোর্ট থেকে নিয়ে এসেছিস সেটা তো
No, this is a very bad one.
No, where is the book?
That there is a typographical error. I do not know from where you got it.
We have from internet we got it.
No, that is what is the problem.
24, 25.
Absolutely, typing mistake in clause 15 itself. Should be with them. What is this?
We shall bring it, my lord. We shall bring the book.
Where it is quoted,
Well, kindly come to first your lordship, just Sri Ramakrishna Fauji, first your lordship come to paragraph 17, Lahore High Court's.
So that is the.
My lord, then the Supreme Court has said is a parameteria. Kindly read below paragraph 17. Appeal to the High Court from judges of the court. And we do further ordain that an appeal shall lie to the said High Court of Judicature, allowed from the judgment not being a judgment passed in the exercise of the appellate jurisdiction, in respect of a degree or order made in the exercise of the appellate jurisdiction by a court subject to the superintendence of the said High Court, and not being an order made in the exercise of the revisional jurisdiction. Revisional jurisdiction. 15 to that. Clause 15. Let us put in that. Your Sukrita. এটার একটা কপি আছে আমার কাছে কোন জাজমেন্ট?
That will depend upon the ultimate judgment which would be rendered. This is thing you can't.
চলো মানে চললে তো ফুলবি যাবে only আর স্কুল যাচ্ছি আরে আমি একটা সিনিয়র দুটো সিনিয়র অ্যাডভোকেট এগেইনস্টে আমি একাকি লড়বো
আপনি আপনি
সিনিয়র
আমরা
অ্যাডভোকেট
পুরো ব্যাটারি একদিকে থাকলো আপনি একদিকে থাকলেও ইউ আর সুপার সিনিয়র ইউ আর নট সিনিয়র
সুপার সিনিয়রের কোনো গ্রাউন্ড নয় তারপরে হেভি ওয়েট সিনিয়র অ্যাডভোকেট I am very happy. 80% have got senior ground, I am very happy. এছাড়া অন্য সব জায়গায় সিনিয়র গ্রাউন্ড সব দিল্লিতে তো দেখলাম কাদের সব দিয়েছে দিল্লিতে তো বলছি এখন যার দিল্লি থেকে সিনিয়র গ্রাউন্ড ওদের তো অনেক বেশি আই এম ভেরি হ্যাপি আমার মনে হয় 80 আমার 80 কেন করবো 800 নেক্সট বার ওকে অ্যাপ্লাই করি কত বয়স হলো হ্যাঁ আরে পার্টি কবে দিবি বল ম্যাডাম আরে দিল তো বেনারসের প্রসাদ খাইয়ে ছেড়ে দিলে হবে না 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 ও অনেক হয়েছে পয়সা খরচা বাপের জন্য তো কোনো পয়সা খরচা করলেন না পয়সা খরচা করানোর সময় হলো এদিক ওদিক হলো আমি তোমার সিনিয়র কম্পিটিশন আমি আমার জুনিয়র অ্যাডভোকেট জন্য হতো আমি করেছি তা দীপঙ্কর তো করেছে হ্যাঁ দিতে পারছি আর ও তো সিনিয়র তো ঠিক করতে পারবে না সে কথা রিট ওরও পার্টটা হবে না তো রিটটা শেখা আমার ক্রিমিনালটা শেখা ওখানে সিভিলটা শেখা আমার পয়সা খরচা করতে আজ পর্যন্ত পয়সা খরচা করেন নট এ ম্যাটার অফ জোক very But just can I take for 1 minute? See clause
23
just similar clause 23 of the latest petition of our High Court. There the question lies, according to me. Similar, kindly excuse me, only one. Extraordinarily original criminal jurisdiction.
No.
23?
23 is a jurisdiction as to the persons.
কি রে, কোথা থেকে
What
দিলি
you are
এটা?
reading?
এটা কারটা দিলি?
Jurisdiction has to person
22.
22 is ordinary original jurisdiction of the
Anyway, Malad, kindly see 23, next 24, possibly, no,
24 is extraordinary or original criminal jurisdiction.
original criminal candidate. This. I don't know why it's not telling. It's the latest one, or I don't know. And we do further ordain that the said High Court of Judicature at Fort William in Bengal shall have extraordinary original criminal jurisdiction over all persons residing in a places within the jurisdiction of any court, now subject to the superintendence of the Saddar Nizamut Adalat at
You
Calcutta.
are reading something else. It is not there in the book.
This is
sir, sir, আমরা রিলাই করছিলাম this is not correct. এই বইয়ে এখন
Not,
can I?
please
এটা
look
নিন,
at that 24.
Yes, yes,
কোথা থেকে সব আসছে এগুলো তাহলে?
Look at this 24 you have handed over. Devani Sadar Adalat has
চেঞ্জ হয়ে গেছে
been omitted.
হাইকোর্ট হয়ে গেছে
I tell you, Mr.
All right, can you just see? Just 24 is extraordinary criminal, original criminal jurisdiction. আচ্ছা বই আছে দিছো?
Yes, yes.
Extraordinary criminal jurisdiction. ঠিক আছে? On we do further order that the High Court of Judicature at Fort William in Bengal shall have extraordinary original criminal jurisdiction over all persons residing in places when the jurisdiction of any court now subject to superintendent of the state High Court shall have authority to try it at its discretion any such person proves to consider. Now 25. And we further order that there shall be no appeal to the said High Court of Judicature at Fort William from any sentence or passed or made in any criminal trial before the courts of original criminal.
That is what I'm saying. That has been abolished subsequently. What you have better experience than all of us. Being a more veteran in the profession. Previously, the High Court used High Court had a power to conduct a session trial. So that was there. They used to.
I know
You have seen that.
I know that.
Last one I saw, you must have seen more.
No, one was
Only
continued
one.
for years.
So that is, you saw also, and we saw also jury trial and all, everything was there. Later on, this has been abolished. And that has been taken to district court for that. So these were the provisions initially that the High Court was exercising the original criminal jurisdiction.
Correct.
But the difficulty, I think, Ramkishan Fauji is there. There's no doubt about it. But the trouble is because, as you know, you
yes,
expressed very clearly
correct.
to have a proper assistance from you, all of you.
Correct.
But Justice Radhakrishnan, in a subsequent judgment, that is in Gopal Kumar Agarwal,
Correct.
he considered Ramkishan Fauji.
Correct.
What troubles us in two things? Please enlighten us on that.
Yes.
He interpreted Ramkishan Fauji in a particular manner and ultimately arrived at the conclusion at paragraph 27. He says that yes, the appeal would not lie, but in what situation? The situation is if there is a quashing of the criminal proceeding, or by virtue of an order passed by the court to initiate a criminal proceeding, then in these two situations, appeal would not be maintainable. Means only against the final order quashing the entire proceeding, not against an interlocutory order which is passed. And then paragraph 28, he held that appeal is maintainable.
My lord, kindly read.
Please read.
Paragraph 27.
27.
We have no disagreement. We have no disagreement with the proposition of law propounded in the aforesaid decision.
Yes.
However, in the facts of the present case, the order of the learned single judge neither resulted. Correct. See, neither.
What I want to
neither resulted in initiation of the criminal proceeding, nor in quashing of a criminal proceeding. The facts of the instant case from the facts of the Delhi case discussed above. Now, this is
28.
For the efforts, we hold that the present appeals are maintainable and not barred by clause 15 of the latest patent 1865. Now the merits of now let kindly come. Then one has to take which judgment I will take. Ramkishan Fauji has been clarified, kindly come then.
Paragraph 22.
I'm
Please
coming.
come to paragraph
Yes.
22 of that
The
judgment.
facts of the facts in the case of Ramakrishna Fuji are different from the facts in the present case. In that case, the learned Singhania order had a consequence which was clearly criminal in nature. The learned Singhania opined that the recommendation of the Lokayukta for registration of FIR against Ramakrishna Fuji deserved to be quashed, and accordingly quashed the same and also quashed the action taken pursuant to such
This is what a
recommendation.
distinguishing feature he brought. That suppose in the instant writ petition, I am telling you, there are two situations that may come. Either the court will dismiss the writ petition, saying I am not going to quash, or the court may quash it, saying that I am quashing the FIR. There are two situations because first prayer is like that, quashing of the proceedings. So either of these will come. Suppose just out of sheer exchange or view,
My lord,
if he quashes it,
No appeal.
then Ramakrishna Fuji says no appeal lies.
correct.
But if he refused to quash, then the Justice Radhakrishnan's view was that it does not create a fetter in maintaining
Correct.
because in Ramakrishna Fuji, the criminal proceeding was quashed. And thereafter, this is what a distinction in paragraph 27 comes. Please correct me. if I
Yes,
am
my lord.
wrong.
Yes.
My mind is still open.
Correct. I understand. I will tell you, Lord, I correct. Finish. My lord, can I start now? See, let me first.
On a maintainability, Mr.
No.
Mr.
I tell you, my lord.
Only on maintainability.
Let me first express my view, then I will come. But my view is this. My personal view is this. Of course, take it as a personal view reading in this.
Then let us.
My personal view. No, doesn't matter. Let it. That's I am talking about law. I am talking about law. I am not talking anything. Every lawyer has his own reading. Every judge has his own reading. Interpretation of the things differs from man to man. Today, Ramakrishna Fuji is there. Tomorrow, any other bench, 5 years old Ramakrishna Fuji is not correct law. These are we have seen that. In an article 226, it's a right for establishment of the fundamental right or constitutional right. Breach. Broadly, I am talking about, broadly. This is available to High Court. Very recently, I did one matter. I am taking cue. I will tell you the sentence which has been used by the Supreme Court in that matter. High Court entertains 226 is the original jurisdiction. 226 civil, criminal, etc. Now, last few years, fortunately, unfortunately, a practice has been developed because of Arnab Goswami's case, entertaining quashing of the proceeding, granting bail, and Calcutta High Court has passed so many orders. No coercive stays, other way the bail is given, anticipated bail is rejected. Now the point, now it has come. Earlier it was not there. Earlier either, it was very difficult in Calcutta High Court to entertain a writ petition is in very rarest cases is entertained when seeking for quashing of the criminal FIR, etc. Because everybody, if you have a case, go to 482. But anyway, last 3 years, a practice has been developed in Calcutta High Court with great respect to all the judges. Whether even that matters have not been settled, decided as yet. 3 years, 4 years, one is enjoying. Now the point, the interim order, don't arrest. No court system. That means what? You are exercising the power of the anticipatory High Court's jurisdiction. Therefore, question is other way it can be done or not. It was not there. Now, although High Court under Article 220, there is no bar to entertain a writ petition questioning the FIR. No, there is no bar. Bar would be exercised or not, power would be exercised or not is a different matter, but power is exercised. Now, interim order has been passed in a criminal proceeding. I mean, quashing of the proceeding. When a writ has been entertained, interim order has been granted. Against that, when an appeal is filed, Calcutta High Court is saying no appeal is maintainable. Granting an interim order, non-granting an interim order is equally standing on the same footing or any direction has been passed. Question is whether in an interlocutory stage, even an appeal is maintainable so far the criminal jurisdiction is concerned. When you are exercising power, but my personal view is, it should be, chance should be given to the litigants. Very recently, I did a case on the basis of a Supreme Court judgment challenging the order, of the National Green Tribunal. And the Supreme Court has already decided, yes, National Green Tribunal's order, writ is maintainable. Writ is maintainable. Reasons have been given for that. One of the reasons I am saying, that it is not possible for the peoples of the country to run to the Supreme Court and file an appeal. Question is, there, really it's a alternative remedy, efficacious remedy or not. Leave aside everything. I hear state has come up as an appellant. Earlier cases, very rich persons, powerful persons, Sukhendu Adhikari had prepared an appeal. Anyway, but every litigant cannot come, It is not possible for every litigant to go to the Supreme Court. There are poor and poorest peoples are also there. Because of the law which has been laid down in Ramakrishna Fauji and subsequent thereafter, it has created a bar. Now, let me read the Ramakrishna Fauji's case. Leave aside my personal view. Now I am coming. What is the views have been expressed by Ramakrishna Fauji's case? Let's read it kindly.
Only one query on that. I also want your reaction or argument on that point also. A judgment of the Supreme Court is interpreted by a coordinate bench of the court in a particular manner. Now, subsequent coordinate bench, if he thinks that that interpretation does not appear to be correct, then what would be the course? Whether there are two things: either the other coordinate bench is bound by that interpretation, or understanding, or explanation, explaining or explanation given for that judgment, or he can take a dissenting view on that. That appears is like that. So, what is your reaction to it? Because this Gopal Kumar Agarwal judgment, I really just now we read it, 27 and 28. That really.
But read the Justice Talukdar's judgment. Justice Talukdar's judgment.
Now another avenue will come, because this is the earlier judgment of the bench, and Justice Talukdar's judgment.
Talukdar's judgment
is a latter one.
Yes.
Now whether this judgment was taken into consideration by Justice Talukdar.
Of course.
And now, suppose if the Justice Talukdar has taken a dissenting view to it, then what would be the proper course?
No, proper cause, kindly I see.
Or I do not know whether he has taken a dissenting view.
No,
No.
May I clarify?
No, please. Mr. Mujumdar, I know little bit of these things. I know little bit of it.
No, I'll appear.
Let
Let clarify
me
the
finish
position.
it. Every time all you, kindly see, against the judgment of the Justice Talukdar, SLP was preferred by state. That was not entertained. Two reasons are there. What has happened, my lord, against the single bench order, judgment of justice, that was single bench, justice, single bench, appeal was there preferred, and also against the order of the learned single judge, special petition was filed. But incidentally, that special petition against the order came up before the Supreme Court. And I had the privilege to argue the matter. First matter that came up, my lord, and the Supreme Court said, all right, we are not going into the merits. What we are doing it, we are saying the single bench to decide the matter expeditiously. Matter is coming up within few days. Naturally agreed to that, all right. Disposed of. When the appeal court's order, this SLP was filed, Supreme Court said that since we have already said the matter should be expeditiously heard, we are not entertaining the SLP. This is the two matter. Effectively, on merit, it has not been decided whether the judgment of the Justice Talukdar division bench presided is correct or not decided by the Supreme Court. Now, my lord, your lordships, if you want to differ, or refer to the larger bench, I have no difficulties. But again, I am saying, I will be happy. I will personally be happy. But I have to discharge my duty. I'll be discharging. Because I appear for the poor litigants of this state in number of matters. It is not possible for to go there to up to Supreme Court. That I understand. Now, anyway, I have to discharge my duty to your lordships, not come to Ramkrishna Puri. First, let me read it again. First, my lord, paragraph 4.
Civil writ.
Civil writ
Petition.
asking for quashing of the order of the locauto to initiate the proceeding. That was the order. Then, my lord, kindly come to paragraph 8. Questioning the sustainability of the order passed by the division bench, Dr. Rajiv Dhawan, learned senior counsel, has raised a singular contention that the LPA preferred before the division bench was not maintainable inasmuch as learned single judge had exercised criminal jurisdiction. The point is not whether the single judge had exercised criminal jurisdiction or not. Now, my lord, kindly come. Here the two questions was that civil, etc., civil criminal. I am skipping up. Then we have 227 maintainability, etc. Kindly come to me, lord.
Up to paragraph 16.
Yes, 16. The maze needs to be immediately cleared. In the instant case, we are really not concerned with the nature of the post held by the Lokayukta or Upayukta. We are also not concerned how the recommendation of the state authorities is to be challenged and what will be the procedure. Therefore, as has been held by this court, neither the Lokayukta nor can Upayukta direct implementation of its report, but it investigates and further investigation. If it is found a public servant committed criminal, prosecution can be initiated. Having discussed the aforesaid at this juncture, refer to clause 10 of the latest patent. Otherwise, the Punjab and Lahore High Court is absolutely opposite. It is as follows. And we do further ordain that an appeal shall lie to the said High Court of Judicature at Lahore from the judgment not being a judgment passed in the exercise of the appellate jurisdiction, in respect of a degree or order made in the exercise of the appellate jurisdiction by a court subject to the superintendence of the said High Court and not being an order.
More or less the replica of clause 15.
Clause 15, they have said so. Now, my lord,
18 is made.
on a plain reading of the aforesaid clause of later patent, it is manifest that no appeal lies against the order passed by the learned single judge in exercise of the criminal jurisdiction.
What is saying? That is the
Thus, kindly pause for a moment here. Kindly excuse me, kindly pause for a moment here. Granting of an interim order, not granting of an interim order in a question of FIR was in. Whether the power is being exercised by the single judge in criminal jurisdiction or not. If you hold no, it is not a criminal jurisdiction, appeal is maintainable. If you hold no, it is a criminal jurisdiction, then appeal is not maintainable. Nature of the order is not the, what is the nature of the order is not concerned we are. Concerned we are whether it is exercising the power in a criminal jurisdiction or not. You go there, appear, you go not to go, that's not, we are not concerned about that. We are concerned what jurisdiction? If you hold no, it's not a criminal jurisdiction, appeal is maintainable. If you But if you agree with this, yes, it's a criminal jurisdiction, then appeal is not meant. That's the question that is required to be posed, whether learned singer is obtaining factual matrix as exercise criminal jurisdiction or not. Paragraph 18 has a question has been made. How? Take the factual matrix of the case.
That is what then straight away come to paragraph.
Man, I just kind. Lots of you will rise now.
This is
You're
what you say is again 22, a small paragraph. This is what you say. Paragraph 22.
From the aforesaid authority, two aspects of the absolutely clear. First, where an appeal is not excluded against the judgment of a single judge of the High Court, an appeal would lie to the division bench. And second, if the appropriate legislature has expressly or by necessary implication not taken away right of appeal, the appeal shall lie from the single judge under clause 10 of the latest patent to the High Court.
So if there is a embargo, then it will not. If there is no embargo, that it is the right to be considered.
Now, my lord, lots to rise, and I think time.
Not that. If you continue, we can continue.
No, I
It's
don't
only
mind.
on the medical advice, nothing more than that.
No, I don't mind. I am not saying, but they have come. That's the reason. No, I have nothing to say personal, my lord, that whether rise, non-rise, that's the all what's this matter. করিস না, চেঞ্জ করবি। I will take some time to your lordships to read the judgment sentence. Will you kindly come to paragraph 28. The court in Ishwardal Bhagwan Das case referred to Article 133 of the Constitution and took note of the submission that the jurisdiction exercised by the High Court as regards the grant of certificate pertains to judgment, degree of or final order of a High Court in a civil proceeding, and the civil proceeding only means a proceeding in the nature of a trial as a civil suit, and a petition for the issue of a high prerogative writ by the High Court was not such a proceeding. It was urged that even in the proceeding for issue of a writ under so and so, in certain case be treated as a civil proceeding. Clear paragraph. Kindly come to paragraph 28, last part. The expression of civil proceeding is not defined in the Constitution nor in the General Clauses Act. The expression in our judgment covers all proceedings in which a party.
Which one you are?
That paragraph 28
of
Ramkishan Puji. I was reading Ramkishan Puji earlier.
28 Placitum.
Placitum. Next page. 28. There is no Placitum.
You are reading a quotation.
Pardon?
You are reading a quotation.
Quotation. The court delving into nature of civil proceedings noted that. Then paragraph 8 has been quoted.
Yes.
The expression civil proceeding is not defined in the Constitution nor in the General Clauses Act. The expression in our judgment covers all proceedings in which a party asserts the existence of a civil right conferred by the civil law or by statute and claims relief for breach thereof. Very importantly, Millard. Then 20. After so stating, the court elucidated the nature of the criminal proceeding, and in that regard ruled that a criminal proceeding, on the other hand, is ordinarily one in which, if carried to its conclusion, it may result in the imposition of a sentences such as death, imprisonment, fine, or forfeiture of property. It also includes proceeding in which, in the larger interest of the state, orders to prevent apprehended breach of peace, orders to bind down persons who are a danger to the maintenance of peace, and so order aimed at preventing the order are contemplated. Then criminal proceeding has been explained here. Then explaining the concept further, the court opined that the character of the proceedings in our judgment depends not upon the nature of the tribunal which is invested with the authority to grant relief, but upon the nature of the right violated and the appropriate relief which may be claimed. It further then come to paragraph 31. The aforesaid authority makes it a very clear distinction between a civil proceeding and a criminal proceeding. As far as criminal proceeding is concerned, it clearly stipulates that a criminal proceeding is ordinarily one which, if carried to its conclusion, may result in imposition. One sentence to it can take within the ambit the larger interest of the state, orders to prevent apprehended breach of peace, and orders to bind down persons who are a danger to the maintenance of the peace. The court has ruled that the character of the proceeding does not depend upon the nature of the tribunal which is invested within the authority to grant relief, but upon the nature of the right violated and the appropriate relief which may be claimed. In this regard, Umaji, the paragraph 32, Umaji Keshav Mesaram has been quoted. Then paragraph 92 of that judgment has been quoted. The position which emerges from the above discussion is that under clause 15 of the latest patents of the Chartered High Court, from the judgment with the meaning of that term as used in that clause of a single judge of the High Court, an appeal lies to a division bench of that High Court, and there is no qualification or limitation as to the nature of jurisdiction exercised by the single judge while passing his judgment, provided an appeal is not barred by any statute. For example, while dealing with the issue of maintainability, the court referred to the so and so, so and so, so and so. Then we'll kindly come to 36. In Radhasyam versus Chavina, the issue arose with regard to the correctness of the decision of Surjodaya Ramchandra so-and-so before the three-judge bench referred to Naresh Shiradhar, Mahesh so-and-so. When the court came to the conclusion that statutory does not like to coerce the judgments of inferior courts of civil jurisdiction, where so-and-so backed up the others. Then will not kindly come to this. Article 37. We are of the view that the judicial orders of civil courts are not amenable to statutory under Article 226 and so. That's not very important for us. Now we let kindly come to paragraph 38. In the ultimate eventuate, the three judges bench answered the reference as follows: judicial order of the civil court are not amenable to jurisdiction. Article 226 is distinct from jurisdiction under Article 226. Contrary is stated, Surjodaya is overruled. Then we let kindly come to paragraph 47. Dwelling upon the said issue, the court in Gangaraman Kandaram case referred to the authority in state of Haryana versus Bhajanlal, wherein the court had categorized certain aspects of the case as illustrated, wherein power under Article 2 or the general power under 482 can be exercised. The court gave a note of caution to the extent that the power of so-and-so of causing criminal to exercise so-and-so, that is in the trial court we will argue. Then we will kindly come to paragraph 51. It is worthy to note that a series of decisions were cited on behalf of the appellants herein, including full bench judgment of the Gujarat High Court in Patel Kasidam Lavjibhai and Naratha so-and-so, wherein the full bench considered Article 220 of the Constitution in this so-and-so. The division bench in Sanjeev Ranjan so-and-so distinguished the said decision on the ground that the full bench did not lay down as proposition of law. LPS would be maintainable. Even an order was passed by the learned single in exercise of criminal jurisdiction for the case before the full bench related to this so-and-so.
Because they did not decide it on the.
Now, in the paragraph 80, they quoted. In our considered opinion, in instance, the proceedings can be said to be criminal proceeding, inasmuch as carried to its conclusion that may result into imprisonment, fine, etc., as observed by the Supreme Court in Naran Rav's.
The ultimate charges, paragraph 27 was on that. Yes.
Paragraph 81 has been quoted. From the totality of the facts and circle, we have no hesitation in holding that Lanet Singh have passed an order in exercise of criminal jurisdiction. At the cost of repetition, we reiterate that we have already stated earlier the proceedings were of a criminal nature. Whether a criminal court takes cognizance of an offence or sends a complaint for investigation under subsection 156 of the Constitution does not make any difference so far as the nature of the proceeding is concerned. Even if cognizance is not taken, that fact would not take out the case from the purview of the criminal jurisdiction. Paragraph 52. From the aforesaid analysis, it is demonstrable that the Gujarat High Court has opined that relying on the authority of this court in Ishwarlal Bhavandas, the issue whether the proceedings are civil or not would depend upon the nature of the right violated and the appropriate relief which might be claimed, and not upon the nature of the tribunal which has been invested to grant relief. The division may further opine that even if cognizance is not taken in respect of a criminal case, it would not take out the case from the purview of the criminal jurisdiction. Thus, it has been held that the division bench that when there is a proceeding under Article 2 of the Constitution arising from an order made by a court in exercise of power under the Code of Criminal Procedure, it would be a criminal proceedings within the meaning of the latest patent.
You can't maintain 226 against an order of the court.
Criminal court. Now, come, this question, two parties there. One is the order and is the nature of the proceeding. It deals with the criminal court. But now, our High Court, it is done. No problem. (56) As we find from the decision of the aforesaid three High Courts, it is evident that there is no disagreement or conflict on the principles that if an appeal is barred under clause 10 or clause 15 of the latest patent, as the case may be, no appeal will lie. The High Court of Andhra Pradesh, however, has held that when the power is exercised on Article of the for quashing of a criminal proceeding, there is no exercise of the criminal jurisdiction. It has distinguished the proceedings of the for quashing the FIR under Section 482 CRPC, and in that context had opined that from such an order no appeal would lie. On the contrary, the High Courts of Gujarat and Delhi, on the basis of the law laid down by the courts in Israel so and so, have held emphasis on the seat of initiation of the criminal proceeding, the consequence of a criminal proceeding, and also the nature of relief sought before the single judge on Article 220 of the Constitution. The conception of the criminal jurisdiction as used in clause 10 of the latest penal is not to be construed in a narrow sense. It encompasses in its grammar that the inception and the consequences. It is the field in respect of which the jurisdiction is exercised is relevant. The contention that solely because a writ petition is filed to quash an individual, it would have room for intra-court appeal, and if a petition is filed under inherent jurisdiction under Section 482, there would be no space for intra-court appeal, would create an anomalous, unacceptable, and inconceivable situation. Then, Millard, the provisions contained in the latest penal does not allow or permit such an interpretation. When we are required to consider a bar or non-permissibility, we have to appreciate the same in true letter and spirit. It confers jurisdiction as regards the subject of controversy or nature of proceedings, and the subject is exercise of the jurisdiction in criminal matters. It has nothing to do whether the order has been passed in exercise of the extraordinary jurisdiction under Article 220 of the Constitution or inherent jurisdiction under Section 482 CRPC. In this regard, an example can be cited in the state of Uttar Pradesh. 430 has been deleted by the state authorities to 58. In view of the aforesaid premised reasons, we hold that the High Courts of Gujarat and Delhi have correctly laid down the law, and the views expressed by the full bench of the High Court of Andhra Pradesh is incorrect. Then, my lord, kindly come to paragraph 60. On the aforesaid basis, the division bench, Aditya Jain case ruled that in a proceeding under Article 226 constituting of civil right, the proceedings are civil in
Yes.
Now, my lord, kindly see paragraph 60 I was reading. On the upper division that I have read already.
You have read in between Placetam E and L.
Yes. As proceeding under
The normal
even
nature of the writ petition is not a determinate.
another High Court rules are the said decision has to be carefully appreciated. Nomenclature of writ petition is not the governing factor. What is relevant is what is eventually being sought to be enforced. Division bench observed that as there is a preventive detention, there is a violation of fundamental civil rights. The decision, as is noticeable, was rendered in a different context. We are only inclined to say that the said authority does not assess the proposition expounded by the learned counsel for the state. Now, my lord, kindly come to paragraph 62. In view of the aforesaid prismatic reasoning, the irresistible conclusion is the latest patent appeal was not maintainable before the division bench, and consequently the order passed wherein is wholly unsustainable, and accordingly it is set aside. However, as the state had been diligently agitated in grievance in a legal forum which is thought had jurisdiction, we grant liberty to the state of to assail the order of the learned single judge in accordance with law. But this is the judgment. Now, my lord, your lordship was referring to that the Director General of Police versus Gopal Kumar. Kindly come to Gopal Kumar. Gopal Kumar. Come to paragraph 16 first. In this writ petition, Gopal did not pray for quashing of the criminal proceedings. And naturally so because he is the de facto complaint. Nor did Gopal pray for an order for initiation of a criminal proceeding. Since the criminal proceeding already stood initiated, the order of the learned single judge, which is impugned before us, neither had the effect of causing initiation of a criminal proceeding, nor had the effect of the quashing or terminating of the criminal proceeding. That is the proceeding.
Understand, that is what troubles us. We have noticed this, Mr. Bandyopadhyay. Then, if that being the position, then paragraph 27 could not have been worded in that fashion.
No, paragraph 27.
That is what.
Let's only for paragraph 27, we can't overlook all the judgments and the references. Not with great respect. Let kindly allow me to read this.
Only thing is that once it has come, so paragraph 27, which is an ultimate finding which has been arrived by the court, and that is a coordinate bench. Laying down something.
Read paragraph 21. Having considered the aforesaid decision and several other decisions, the Honorable Supreme Court held that the High Courts of Gujarat and Delhi have correctly laid down the law and the view expressed by the students. That is the paragraph. Now come paragraph 22.
No. Please come to, this has no placetum. Should be a placetum.
On which paragraph?
Paragraph 21. If you come 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line.
My lord, may I request that you kindly give tall tables. It's very difficult to read nowadays. This is down, we can't read. Very difficult. Earlier practice was there.
On a lighter note, about what is the average height of an Indian?
Not the average, not the. You must consider the persons who are.
I have more difficulty.
No. You see.
I have more difficulty.
No, this is impossible to read.
Say,
Eye problem is coming now.
I have more difficulty.
Eye problem can't read. Very difficult, and this is way.
I'm structurally taller than you.
Of course, at that time when you were in practice, unfortunately these tables were not there. That time, tall tables were there, and you have to argue this way.
So can we put it?
Yes, here at least some
court keeper or court management.
I said to the Honorable Chief Justice also. of the order of lands was of criminal nature. By such order, the FIR stood quashed.
That is what is saying.
No, stood quashed, thereby leading to termination of the criminal process. Hence, the order was passed in exercise of a criminal jurisdiction, and therefore no latest pending appeal would lie therefrom. On the sole ground, the Honorable Supreme Court allowed the appeals and set aside the order of the division bench, leaving it open for the state. The facts in this case of Ramkishan Fauji are different from the facts in the present. In that case, the learned say order had a consequence which was clearly criminal in nature.
What I say that what is held is that the consequence is the one of the important factor, the ultimate relief which is given. And the division bench has interpreted that the right of an appeal would depend upon the nature of the relief granted.
Yes.
Nature of the relief granted. That's why paragraph 27 was worded in that line.
Correct.
We say that we have no disagreement with the proposition of law. If you come to paragraph 27.
27.
Yes. Scroll your screen.
Yes, 27.
I'm also high tech, don't worry.
Yes, we have no disagreement with the proposition of law propounded in the apostate. However, in the facts of the present, the order of the learned singer neither resulted in initiation of criminal proceedings nor in passing of it. The facts of the instance are different from the facts of the.
He borrowed from this paragraph 21 and 22.
Kindly see.
He borrowed this expression and then say, now
what was the case? Excuse me, Milord. Excuse me. Here in Gopal's case, is regarding the transfer of investigation. I have no disagreement regarding transfer of investigation. That's a different thing.
By deciding so, the court has held. Now, Justice Talukdar, I find, in his judgment, has said that this judgment of Gopal is distinguishable on facts.
Correct.
And therefore, he held it. Now, there are two judgments operating in the field. And I'm saying, a interpretation by a coordinate bench of a judgment of the Supreme Court in a particular manner, and an interpretation of the judgment of the Supreme Court by another subsequent coordinate bench in a particular manner. Now, when both are placed opposite to each other, there appears to be some kind of a conflict that is there. Now, as a third coordinate bench, what we are supposed to do?
Milord,
forget about
I'm telling
you.
No. If your lordships, just 1 minute, Milord. If your lordships do not agree with the proposition laid down by the division bench of Justice Talukdar and agree with the proposition made by the Chief Justice, the then Chief Justice, of course it has to be referred to the larger bench. No doubt.
That is what I'm saying.
No, there's no problem. But kindly just allow me kindly just to finish it. What the Justice Talukdar has done in Justice Talukdar's matter, I mean the appeal which was there, their writ petitioner sought for the quashing of the proceeding. Certain interim orders were granted. Then Justice Talukdar said, no, not maintainable. Here in this case, criminal seeking for quashing of the criminal proceeding. They didn't get the interim order as sought for. Then what is the characteristic difference between Justice Talukdar's judgment and here? Rather, is the case completely distinguishable. My lord can refer it. I don't mind.
Please try to consider, because when the third judge comes or the third bench comes, and it appears that there are certain things which are really overlapping to each other.
Refer it. I don't mind. But if you want to grant an interim order, then you hear me on merit on that matter.
You respect me. The principle laid down in Ramkishan Fauji's case, Gopal Agarwal's case, and the recent Suparna Kanjilal's case, the same fact has been time and again has been reiterated by the Supreme Court as well as by the High Court. What they said, the relief was granted invoking criminal jurisdiction. Now, the relief in Ramkishan Fauji's case, your lordship will find it was quashed. So relief was granted. In the Suparna Kanjilal's case,
there are certain observations which need to be gone into. and to be taken up, because we find Ramakrishna Fauji's case also, we have extensively gone into it. We have extensively gone into this Gopal Kumar, and now this Suparna Kanjilal.
Yes.
What we find is that so far as the principle of law, which is the basic principle of law, which is there appears to be some kind of a conflict. I think in order to bring a certainty, I think that conflict has to be ultimately decided.
But with due respect to your
and to be decided by a larger bench, and the larger bench may take care of whatever is there. So this is what we feel, because we do not want to express our mind into this regard, because we have seen all the judgments in extension. There is a scope for both the sides to argue. There is a scope, I believe, a lot of interpretation. Better.
Your lordship can do that, but
Three-judge-
my humble
three-judge-
submission is this.
Three-judge bench, let the three-judge bench decide this issue. It's a very interesting idea.
Yes, yes. But that's one thing I want to just, your lordship can do that. But I have no issue.
I have something in mind. My brother has something else in mind, and the learned judges have something else in mind. So it's better. So let it be brought within one compass. Let it go.
But will not interim order, your lordship, has last occasion protected us?
I think there is nothing which
No,
has
in
come
written,
out
but
as
there
of
is a
now.
verbal assurance that they will not take any steps.
I think there is nothing which has come out as of now. So naturally, if the occasion so arises, you are definitely entitled to pray for an interim order. So yes, where is he can take it here if he has gone to take a water. Never say anything to the appearing member of the council.
But, my lord, I really wanted to argue this before your lordship's court, because what I find, my lord, here the single judge did not, my lord, exercise his criminal jurisdiction. Your lordship kindly remember, here we have challenged the notice under section 160, which is administrative in nature. It is nothing to do with, my lord, any code, my lord, from the code of criminal procedure. 160 notice given to a witness. But if it has no consequence so far as the sentence or fine is concerned. But 160 notice, but
only the witness.
Yes. So there is no consequence so far as the sentence and fine is concerned, which the Supreme Court has said in Ramakrishna Fauji's case. The consequence where the imposition of sentence and fine will be there.
That is what
then only will
the
criminal jurisdiction is.
Radhakrishnan has also said so. The Justice Radhakrishnan has also said
Yes,
so. But
जज की बोल मेंटेनेबल जज साहब की बोल मेंटेनेबल
so let the point be decided.
But I am praying for interim protection.
I
have no
witness. What protection you have?
No, because Milord, I am relying on one judgment which my learned senior has argued. Milord, kindly see this. Why you are apprehensive? Why you are apprehensive?
Not apprehension is not
No,
the basis for getting an interim order.
That exactly Mr. Bandyopadhyay has argued.
No,
Milord,
no.
kindly see this.
No, I have
Kindly
not.
see this.
I have said about this. Only I had a talk. Then I will show you the merit of the matters.
You will get then Mr. Bandyopadhyay, they are the appellate, they have a right to begin.
Yes,
of course.
Milord,
I am
same
not.
situation here, and kindly see the interim order has granted. Mr. Bandyopadhyay argued this matter.
Which case? Huh? Subodh Adhikari is a different matter. Subodh Adhikari was a different matter.
Section 160.
Yes, ED.
The investigating agency is same.
This is not a judgment. It is an order.
Mobile type code. But here also situation is same. I am not named in the FIR nor in the charge sheet. On the basis of suspect, the 160 notice has been given to me.
Yes, Mr. Bandyopadhyay, we are, what we propose
Pardon?
to send it to a larger bench for these judgments. Let the point of reference be decided, whether the appeal in such nature will lie or not. And let the court decide on that, because what he says is that he's not really asking for the quashing of the FIR
FIR or charge sheet.
or charge sheet. He is asking for a quashing of a particular notice, which is administrative in nature. But the relief as is couched in the writ petition is something which really creates a confusion in that. In that regard, we wanted, and in view of this conflict between the Justice Radhakrishnan's judgment, rather I would say Justice Orijit Banerjee's judgment and Justice Sutamitha's judgment.
Justice Orijit Banerjee has also delivered another judgment. I have not brought him. Division bench.
Sitting in a division bench, he was an author of the judgment.
He was also author of a judgment when he was presiding as a judge.
Does it create any bar in the judge?
No.
He can take a...
No, same. No. There's no problem. I am not saying so. I am just telling. Don't take me as your opposition every time. Don't take me as your opposition every time. I am just...
Notice which...
Last, they have called me on 18th of November.
Where is a notice?
But recent...
So why it is bad then? Then one has to say. Okay. Where?
Where is that notice?
By way of a supplementary affidavit, we have given it to your lordship.
Where is that?
Yes. The first notice your lordship will get that.
Where is that? Supplementary affidavit?
See that.
Where is the supplementary affidavit?
The first notice, after first notice, your lordship will get
it to them. Copy has been given.
Yes, their notices.
Notice I have given. There are a lot of things I have given. Give me the supplementary affidavit.
Now, first, kindly take my petition.
Let him give a copy to them. Or give it to
No, we have
copy to them.
Yes.
Already served.
We will not.
Already served. Last occasion we have served.
First, you say that yes or say no.
Yes.
Kindly see the petition. First, kindly turn to the petition before that.
No, I want to look at the document. Which is the notice? First, paragraph, page 7.
Yes.
Yes.
How is CRPC?
CRPC job কালো বইটা
এই আমাকে ওই ইয়েটা দাও তো। ওই ছোট একটা ব্রিফ ছিল, কোথায় আছে? Let's see about this.
same notice, the same language and everything is the same. What's the notice?
Yes.
So why you say it's an administrative notice?
Well,
just wanted out of inquisitiveness and the curiosity about this branch of law. I'm just asking you.
Yes.
Why you term it as an administrative notice?
160 notice is a decision, it is in the statute. but it is the decision of the investigating officer to give a notice to a witness. But if I can show from the case record, the investigation is biased because the allegation on which the FIR was registered, the petitioner is not named in the FIR nor in the charge sheet. After filing of the charge sheet, after
Confusion is there. Yes.
Can I start? Can I start?
may I place the facts of the case once? Then your lordship will understand the whole crux of the matter. Just it will take 3 to 5 minutes time. But kindly say it, my lord. But the FIR was registered, your lordship will find in page 42.
There is one clarity I want from you, because your argument is that you are really challenging that particular notice.
Yes.
160. Now, this notice, according to you, is only a notice upon a person to appear as a witness.
Yes.
And according to you, it is an administrative action or a deed or a notice which is capable of being challenged in a writ petition. But as it appears from the relief which you have claimed in the writ petition, that you are really assailing the very registration of an
No, my lord.
FIR.
No, I stand corrected.
Please,
My lord, kindly see the prayer.
Look at the prayer.
My lord,
Prayer
kindly
eight.
see the prayer. My lord, kindly see the
Come
prayer.
to prayer
I have
eight
never
and
said that.
55.
Yes, my lord, kindly see the prayer, my lord.
Please come to prayer.
Page 55.
Yes.
Issue B. Issue
No, no,
read
A.
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 Dispense with the
Oh, B.
B.
Sorry, B.
Issue writ or nature of mandamus directing the respondents and their men and agents to assign to show cause as to why the investigational proceeding. So I have never challenged the FIR or charge sheet. In this case, FIR has been submitted, filed.
Investigational proceeding.
Proceeding connection with Bhatpara police station case number so and so, qua the petitioners, not the entire investigation I have challenged. Qua the petitioners. So I am saying it's a bias and malicious investigation.
Yes.
Let's see, Millard. First of all, come to page 36.
Of the state.
25. I will come to the merit later on, just from the averment. That the petitioner states that the petitioners being helpless against the continuous malicious, malafide and vengeance filed actions of the state authorities in invoking the jurisdiction under 226 of the Constitution of India before this honorable court for protection of their personal liberty and fundamental for being violated repeatedly, so and so. What violation? What is the way? That has not been said. Completely a vague read. The petitioners have approached this honorable court seeking the quashing of the FIR on the ground that the said case rigged, malicious and malafide approach. Now you read the prayer. How the entire investigation can be quashed? On what basis? Investigation cannot be said to be malafide at anywhere. If the proceeding is not malafide, proceeding is not questioned, then the investigation is a complete, is a automatic result of the investigation.
Yes.
I can't understand, Milord. You kindly record this submission that he is not asking for the quashing of the FIR or the charge sheet.
What is saying?
That's all right. Kindly record that, because matter it every. Please, sir.
Please, you did not have to be so.
With the folded hand. Now, what are the allegations here? Why I am asking for investigation? Milord, these kindly say charge sheets have been filed. So far, the petitioner number 2 charge sheet has been filed. And so far, the petitioner number 1 is concerned, it has been mentioned in the charge sheet, he is a suspected person. I can hand over the charge sheet. Now, what is the allegation is? Allegation is one Mr. Arjun Singh, who was the ex-MP, who is now ex-MP, that is member of parliament. He was a chairman of the cooperative bank. By showing some fake orders, Arjun Singh has granted loan to the petitioner number 1. And the loan which has been given to him for the order, that has been diverted for other purposes. And who is the petitioner number 1? On record I am saying, according to our investigation, although the marriage has not been taken place, but she is the second wife of Arjun Singh. Oh, that's why I'm on record I am saying. No. On record I am saying, kindly bear me, Milord, bear me.
Personal.
No, not a personal. I have to show the interest. Not that, Milord. It's not everything is personal. Why she has given to him this benefit? That's also what is the mainstream? My lord, stop me kindly do not stop me in this way.
No, I will, because the choice of word is not appropriate in this regard. but my brother has to dictate one judgment first matter. Yes, the dictation is complete. The order will be passed now.
There was a matter fixed, my lord. I mentioned in the morning, my lord, at 2 p.m.
No,
Lordship
this
was.
is the continuing matter. We have to dictate the order. Okay. Duজন কে ডাকো।
Deeply obliged.
Yes, yes. On the next.
My lord, I had mentioned the matter, lordship said permitted to fix it at 2 p.m. lordship. This is a matter that I had mentioned the matter in the morning, my lord. The Honorable Chief Justice had granted me leave to move this matter upon dispensation of Rule 26. My lord had permitted to. It's a very small matter, yes, my lord.
What is it?
My lord, writ petition, my lord, has been filed by the illegal.
For him. He has granted leave.
My lord, with your lordship's leave, my lord. My lord, writ petition had been filed, my lord, by the illegal occupant.
It's for the respondent.
My lord, I have served a notice upon the respondent. Kindly.
What is an urgency that?
My lord, urgency, my lord, is, my lord, the electricity board, which has been granted permission to install electricity. They have issued a notice, my lord, which I've annexed with my stay petition, my lord, at page 52, that they are going to install it. They had to install it on Wednesday, my lord, yesterday, my lord, Thursday. However, my lord, upon notice, they have kept it at abeyance till this week, lordship. At page 52, my lord, will come to the notice. My lord, 55, my lord, page 55, annexure I. Now, the impugned order, my lord, is at page 53.
What are you talking about? This is a simple case of connection to be given.
Yes, my lord. My lord, my case is, my lord, that this writ petition was obtained ex parte without service upon me.
Service was there. You
No, my lord. My lord, I have annexed the letter, my lord. Kindly sees, my lord, page 52, my lord. Kindly sees page 52, my lord. The letter contains a wrong writ petition number. My lord, the letter contains a wrong writ petition number. At page 52, my lord, the letter is there. Kindly sees, my lord, the writ petition number is 18334, whereas the writ petition number is, my lord, page 52. The service letter which was effected on me. My lord, I am the private respondent. Page 52 of my application, my lord. My lord, the writ petition number.
18334. And
Yes, my lord. That is it. And yes, my lord. My lord, I was not aware of this, my lord. It was running before the list of Honorable Justice Shampa Sharkar in the monthly list. Thereafter, upon change of determination, they've mentioned it without notice upon me. And on the first day, my lord, this order has been obtained, my lord. My only simple point.
What is expected from an advocate at the court?
My lord,
you may have received a letter which contains a wrong number. But this letter contains the name of an advocate.
my lord, I have.
Given.
Yes, my lord, I have.
Immediately contacted him and say that, look, I am appearing for the respondent. You have given me notice. Anything you do, mention the matter. Please give me a notice.
My lord, we had done so, my lord. My simple point, my lord.
Communicated.
My lord, my simple point is, my lord, the Honorable single judge, my lord, has.
I know. You just tell me your bona fide for show. That we will consider later on. But the interim order, when you want, you have to show us your bona fide. Where is your letter? You communicated to.
My lord, I don't have a. My lord, I don't have a letter for that, my lord. But I was pursuing, my lord. My only point is, my lord, that I am the owner of the property, my lord. The writ petitioner has contended that I am also not the owner, my lord. And my lord, without hearing me, that electricity connection is installed.
Whether this gentleman is the occupant of the property.
I beg your pardon, Lord.
Is he an occupier?
My lord, he is the illegal occupant. That question has not been considered. My lord, kindly considers these judgments, my lord. I'm relying upon these judgments of the
special bench judgment of our High Court of Justice Pratap Kumar Ray.
My lord, kindly considers this, lordship. My lord, this is on.
Shows that under the 1910 Act, 12(6) was there, which talks about the illegal. But after this new act has come, but it says
the issue of whether the occupier. Lord, whether the occupant is, my lord, in legal occupation or not, my lord, that has not been considered at all by the learned single judge, my lord. My lord,
judgment you are relying.
My lord, this is 2000. My lord, 2006 post CHN. Division bench, lordship.
Special bench is there.
Special bench is against you.
Lord, kindly gives me protection at least till
Second-
Monday, my lord. Let them come back and give an affidavit on my stay application.
The section says is a owner or occupier. It does not create any distinction. I'm telling you,
My lord,
you have not read the earlier act. Have you read the 1910 act?
no, my lord.
There is a section 12(6). If you have the gadgets now,
Yes, my lord.
go to 1910 act.
Their occupier was qualified with the expression lawful.
Lawful occupier.
Now it's only the occupier.
It's only the occupier.
Section 43.
Yes, my lord.
The
Section
question
43.
arose that whether this lawful occupier would remain. Justice Ray says, no, no, no. The rules are framed, saved. Those have not been amended. So lawful occupier, he should satisfy that he should be a lawful occupier. Prior to that, Justice Jitin, what's it? Gitesh Ranjan Bhattacharya's judgment is also ignored. But later on, a special bench presided over by Justice Bhaskar Bhattacharya held, no. Occupier has not been qualified. Any person who is found in possession is entitled to electoral connection.
My lord, let this issue at least be considered once by the
Considered-
honorable single judge, my lord.
Special bench has considered.
Lord,
You have
he,
not
lord,
brought
he is
that-
not paying any rent to me, my lord. The lease agreement he's relying upon is not signed.
Internal problem.
Lord, my objections are also pending before the electricity board, on the basis of which, my lord, they had,
Move out. Then we
Lord,
have
at
to
least
decide it and throw him out.
Single bench.
You go better make an application.
Since your allegation is that
My brother has given you some.
you were not served with the notice, we can give you a leave to approach the learned single judge.
my lord, let it be
But-
remanded before the learned single judge, my lord. That will
Not
also,
remand. Not remand.
Lord, if it can be heard afresh, my lord,
You
by the
can be
learned
given
single judge,
liberty
my
to
lord, at
withdraw
least
to
I
take
can at least
appropriate
place my
steps.
opposition before the learned single judge,
Do
my
that
lord.
before the single judge. We can allow you, grant you liberty to withdraw this appeal with liberty to take appropriate steps. That much we can do, or else we have to decide it on merits.
Very, my lord, if that liberty can be granted, my lord, I shall try my luck before the honorable single judge. Great.
After some argument, the learned advocate appearing for the appellant prays for leave to withdraw this appeal with liberty to approach the learned single judge with an appropriate application. Full stop. As prayed for, the appeal stands dismissed as withdrawn with liberty to the appellant to approach the learned single judge with an appropriate application.
Very difficult.
Great.
All judgments are against you.
Lordship, I'm filing one supplementary affidavit, Lordship, with another communal video link and the details, transcription details of the victim persons whose house have been vandalized, looted, and Hindu deity and idols, whatever.
Even after the order is passed by this court.
Lordship, yes, after the order was passed, one communal video have been spread throughout the internet. Lordship, my supplementary affidavit, page number 2, Lordship, paragraph number 5, the video link is there. And Lordship, I can submit the video before your court if your Lordship wants to see that আমাদের বাড়ি থেকে 70-80 কিলোমিটার দূর বেলডাঙ্গা একটা জায়গা। কিছু সনাতনীরা পুজো করতে গিয়ে আল্লাহ তাআলাকে গালি দিয়েছে, এমন একটা গালি যে আমি বলতে পারবো না, অসম্ভব। আমার কাছে ভিডিও মজুদ রয়েছে, দাঙ্গা শুরু হয়ে গেছে, ঝামেলা শুরু হয়ে গেছে। গোটা মুর্শিদাবাদে গতকাল থেকে নেট বন্ধ। আমরা কোনো কিছু খোঁজ পাইনি। মুর্শিদাবাদে নেট বন্ধ, আজকে আস্তে আস্তে শুনলাম 21 তারিখ পর্যন্ত বন্ধ থাকবে। আল্লাহর কাছে দোয়া করছি, কেননা নেট বন্ধ করেছে মানে বুঝতে পারছেন কারা বন্ধ করেছে। তারা বন্ধ করে দিয়ে মুসলমানদেরকে কুপিয়ে কেটে ফেলবে হয়তো, বা যাতে কেউ না জানতে পায়, মিডিয়া কভার না করতে পারে।
144 ধারা জারি করেছে, আমার আল্লাহকে গালি দিয়েছে ওরা, এক্সট্রিমলি লাউড ভয়েস, ওরা জানে না পৃথিবীর বুকে নেট ওরা বন্ধ করতে পারে, আমার আল্লাহ তাআলা মানুষকে ছাড় দেন কিন্তু ছেড়ে দেন না, ছাড় দেন কিছু সময়ের জন্য কিন্তু ছেড়ে দেন না। ফেরাইনের মতো প্রতাপশালীদেরকে আল্লাহ তাআলা লোহিত সাগরে ডুবিয়ে মেরেছে, তুমি কোন শালা কেয়ামতের মাঠে জবাবদিহি করতে হবে, করতেই হবে। কি ভাবছো দুনিয়ায় আমাদের মুমিনদের